So, good morning. My name is Malcolm Neekirk. Today's coffee break briefing is going to be on the old case of Atlantic Computers. And in particular, I'm going to be talking about a couple of aspects of that. One of them is the relationship between insolvency practitioners and the courts, and what we can read from Atlantic Computers on how the courts expect insolvency practitioners to behave and make their decisions. These are the issues I'll be covering. I'll be looking at the background to the Atlantic Computers case, just the facts behind it. Then I'll be talking about how the ruling set the law for administrations and the enforcement of the administration moratorium. And then I want to move on beyond that to look at what I see as the wider significance of the case. So let's start with the background. And Atlantic Computers was, of course, a case about administrations, and in particular, the rights of secured creditors, how those rights are affected by an administration, and the right that secured creditors have got to challenge and breach the administration ring fence. In other words, it's a question about when secured creditors are entitled to enforce their security to repossess their property. And the flip side of that is it's also a case about when administrators are entitled to shelter behind the ring fence and keep possession of goods that belong to third parties, property that belongs to third parties, and carry on using them for the administration. And following on from that, it also deals with what terms can be imposed by the court or the administrator in either granting or denying consent to allow repossession. So let's look at the wider background to this. And administration orders, Atlantic Computers was a 1990 case. Administration orders were a brand new procedure a few years earlier in 1986. So Atlantic Computers was a decision very much at the time when practitioners and courts were feeling their way in unfamiliar territory. Administration orders, as they were then called, were built upon pre-existing procedures of administrative receiverships and liquidations. And they were designed primarily to hold together the distressed business while it went into a formal insolvency procedure and give it a breathing space so that the administrator would have a chance to restructure it or sell the business as a going concern, free from challenge by creditors. And the moratorium ring fence, which was designed to keep secured creditors at bay, was an important part of the new procedure. So looking at the administration order moratorium, the ring fence as it's sometimes described, it was then contained in section 11 of the Insolvency Act, which was repealed a few years ago and is now contained in paragraph 43 of Schedule B1 to the Insolvency Act. It's very, very similar now to what it was originally. And essentially, what it does is restrict the right of secured creditors to enforce their security, repossess their property, repossess their goods while the administration is running. And in all cases, a secured creditor who wants to enforce their security, who wants to repossess their goods, they will need permission either from the administrator or from the court before they can do so. If they enforce their security, if they exercise their rights as a property owner without that consent, they are in contempt of court. Bad things can happen to them. And it is entirely legitimate for conditions to be set by the court in either allowing that consent or refusing that permission for them to repossess. And Atlantic Computers deals with some of those terms that can be applied to set conditions. There's a similar ring fence that also holds out creditors who are litigating against the company, whether they're actually in the early stages of litigation or whether they've got a judgment and they're now looking to enforce it. all of that is also held at bay by the administration moratorium. But there were big holes in the new law as it then was. Although it said that creditors needed permission before they could repossess, it didn't say anything about when the court or the administrators should refuse repossession, or conversely, when they should allow repossession, when conditions could be set by the court or the administrators, and what sort of conditions would be sensible in an administration in these circumstances. So that was really what the Court of Appeal ruling in Atlantic Computers was all about, looking at this great big hole in the law and trying to fit it in with something workable and sensible. So let's have a look at the administration itself, what the facts were around it. Atlantic Computers was a finance business. It leased computers. It had some really good big name customers on its list, and it was itself part of a much larger group of companies that all went into financial difficulties at very much the same sort of time. And this is the way it worked. It was funded by a number of banks who owned the kit, the computers, that it would let out to the end users, its own customers. And the deal that Atlantic Computers had with its banks is that the banks would lease the kit to Atlantic Computers on fixed 7-year leases, but where, banks being banks, the rent could fluctuate with increase or decrease according to what happened to base rates during those 7 years. And the business that Atlantic Computers was in of letting computers out to businesses was that it also let the kit out on 7-year terms, but with one important difference, that the customers of Atlantic Computers had a break clause in their contracts. The leases from the banks did not contain a break clause. There was a second important difference, which was that the deal that Atlantic Computers agreed with their customers was for the equipment to be let on a fixed rent, so that their customer, the end user, would have certainty about how much they would be paying for their rent over the 7 years of the term. And this diagram shows roughly what was happening. You have here the bank leasing the kit to Atlantic Computers on a fixed term lease, but with variable payments. And you've got Atlantic Computers, which is then subletting the same kit to its own customers, the end users, but although it's on a fixed term contract, it is effectively a variable term contract because it contains a break clause and the repayments are fixed. You're probably starting to see where the flaw is in this particular business model, and you're absolutely right. The business was knackered by big rises in bank base rates, which meant that Atlantic Computers was now paying more in rent to the banks that were providing it with the kit it was leasing out than it was receiving in rent from its customers, the end users. The business was no longer sustainable. It went into administration, and the administrators had a plan. They thought what they would do is keep the sub-leases going, because that was essentially what the business was, and they would collect the rent in from the sub-lessees, the end users, so that they would have an income stream coming into the company. They would then bring in other suppliers who could offer replacement leases to the end users, and they would then negotiate an early break with their end users and take a break premium, so that they would set up a new supplier who could lease replacement equipment to the end user on better terms, better equipment, whatever it might be. And they would then say to the end user, we will help you implement this deal, which is going to be beneficial to you in return for you paying us a reverse premium to get out of your existing commitment. They needed to negotiate those break premiums because otherwise there would not be any money coming into the administration other than the declining rental income that they were getting. And that rental income they were receiving was not enough to pay the company's own commitments to the banks for the hire of the equipment that they themselves were leasing out. The banks were unenthusiastic about these proposals. They could see how it would help the unsecured creditors. They could see the unsecured creditors doing quite well out of this, but they were worried that if they allowed this to happen, they would end up holding security over nothing because all of the contracts would have been renegotiated. So they asked for two things. Firstly, they asked for the administrators to pay for the use of the bank's computers while those were being let out to Atlantic Computers customers. And they also asked for permission to repossess the equipment themselves. I guess the bank probably felt that they could also negotiate better terms with the end users, and they would rather do that and use the reverse premiums from that to mitigate their own loss rather than see that going into the administration. Now, just go back to that earlier slide where I said there's nothing in the Insolvency Act to give any sort of guidance to the court or the administrators about when they should allow the banks in a situation like this to repossess their equipment, when they would be entitled to deny a request like that, and what sort of conditions might apply either to the bank or to the administrators if permission was either granted or withheld. So that is what this case is all about. And I think what this case also contains is some really useful guidance about what to do in a case where judge or insolvency practitioners has discretion, as they did here, how they should exercise that discretion. So let's look at the law coming out of Atlantic Computers. And some of the broader principles here are that if you're in any sort of a negotiation where there is an underlying legal issue, then knowing how the courts are going to resolve that issue, how the judges will apply the rules around that issue, that helps you to decide what's realistic in terms of what you can agree with the other side and what you can't agree. And the Atlantic Computers ruling also contains rules specifically about how administrators themselves should make decisions when they have a discretion, when they have to make a decision of this sort. And I think that some of those rules in Atlantic Computers are actually good guidance for all insolvency appointments, not just for administrations. And I'll expand on that a bit later on during this presentation. Back to the actual decision itself, and yeah, spoiler alert, the banks actually won. They were allowed to repossess their kit, the stuff that they had financed from the administrators. And this meant that they were able to instruct the end users, the companies who actually had possession of that equipment, they were able to tell them to pay their rent directly to the bank and not to Atlantic Computers. And it meant that they, and not the administrators of Atlantic Computers, were then able to negotiate fresh contracts with the end users of the equipment. And as a second part of the ruling, the court ordered the administrators to hand over to the banks the rent that they had already collected from the end users. They considered that to be essentially the bank's property, along with ownership of the computers themselves. So let's have a look at the reasons behind all of that. And I think there are two sets of guidelines in Atlantic Computers that are both worthy of study. One is the very specific one that deals with administrations and how to deal with secured creditors who want to enforce their security with the owners of property who want to exercise their ownership rights. The second one is a bit more general and of much wider application, and I think it's about how insolvency practitioners should be making decisions more generally. So in terms of the first one of those, how to deal with secured creditors who want to repossess their kit, or a judgment creditor who wants to enforce a judgment, a landlord who wants to forfeit the lease, any of those sorts of situations where you're looking at a request to lift the administration moratorium, the first question you have to ask is, will it hurt the purpose of the administration if I allow this creditor to do what they are asking to do? And if the administration can proceed without this, if, for example, the landlord wants to repossess a warehouse, leasing a warehouse which is empty or contains goods that you don't need for the purposes of the administration, you may well decide to allow that because it's not going to hurt the purpose of the administration. If it will hurt the purpose of the administration, then you have to assess the balance that will be done to both sides and try and weigh out how to best mitigate the damage to both sides. And for that, you should be looking at both probability and consequences, what the likelihood is of damage happening and how severe it might be. And you're probably familiar with this risk warning matrix that the Met Office used to warn us about how severe bad weather is going to be. And they suggest that we should look at how likely it is that something bad is going to happen and how bad it will be if it happens. And you can combine both of those together to make an assessment of the risk that we face. So that's relevant in deciding whether to allow a secured creditor to enforce their security. You look at what the consequences could be of them doing so and what the probability is of those consequences. But in weighing up the balance, property rights do count for a great deal, and that's because administration, as with all insolvency procedures, it does not change property rights. It does not change who owns property. It does not change who holds security over property, and property rights are considered to be very important. What Atlantic Computers does also say is if there is going to be damage to somebody who owns property, you are very often going to be able to go a long way towards mitigating that damage if you just pay the rent. So if the landlord who wants to forfeit their lease is the landlord of the main trading premises of the company in administration, and you're a few days away from being able to sell the business as a going concern, then there's every likelihood that if you can agree with the landlord that you will pay the rent and that they will accept the rent, then they should be unable to enforce the terms of their lease. They should be unable to repossess, re-enter the premises. The other thing to look at, so those are the specific rules on the administration moratorium that apply mainly to administrators. But I think there are some general principles coming out of Atlantic Computers that are of wider importance to all sorts of insolvency procedures and how insolvency procedures make decisions generally. First thing to remember is that for many procedures, you are an officer of the court. That gives you special powers and also special privileges. And as an officer of the court, you have to use them responsibly. This is particularly relevant in administrations, bankruptcies, and compulsory liquidation, where I think it's fairly clear-cut that you are an officer of the court. It's not so clear as to whether you are or not in, say, voluntary liquidations. But I think these are relevant as well when you're using statutory powers, such as in sections 234, 236, powers of investigation, which are specifically conferred on office holders. Whether or not you're an officer of the court, you've got those powers, and in using them, you should be using them responsibly. Another principle from Atlantic Computers, general principle, is that you need to be quick in your decision making as an insolvency practitioner. In insolvency, things are very often fast moving. If you can't make a decision immediately, then it's entirely proper to make an interim decision while you ask for a bit more time to make your final decision. And that might involve you paying something as a gesture of good faith while you're asking for that time to make your final decision. You have to be responsible. That means that the powers are not given to you for personal benefit. They're given to you in your capacity as office holder, and you should not use your power to grant consent or to withhold consent as a bargaining counter for other unrelated issues. Even if by doing that you would be benefiting the unsecured creditors, that's not a responsible and proper use of the powers that you've got. It's important that you should be reasonable. You should explain why you have made the decision that you have made. It does mean that you could be challenged on those reasons. It does mean they need to be good reasons. It does mean you need to think about it. But that's part of the important checks and balances on the power of insolvency practitioners. And in Atlantic Computers, it was suggested that insolvency practitioners should be judicial. So you should be impartial, you should be objective, you should look at the evidence, you should look at the decision that a court would be likely to make in a situation like that, and you should try and follow that lead so that the decision that you make should be one that the court themselves would be likely to make if it was they making the decision and not you. So those are the 5 points that I've got on my list that come out of Atlantic Computers as points that I think are relevant more generally to insolvency practitioners making decisions. Firstly, you have to bear in mind that you have duties and privileges as an officer of the court. Secondly, you have to make decisions quickly whenever possible, but use the power to make interim decisions as a really useful tool to give yourself the time to make the proper considered decision. You have to be responsible in the way that you use your powers, use them for the purpose for which they are conferred, and do not overextend them. You have to be reasonable, give reasons for your decisions, explain what you are doing, and above all, try and be judicial, try and make the decision that the court would make. And you'll find very often that when you're dealing with hostility, the advice you'll be getting from your lawyers is to be impartial, neutral, objective. Try and distance yourself from the heat of the argument. There may be personal abuse chucked in there as well. Rise above it. Just be objective, impartial, and neutral in how you deal with the issues. So, in terms of the wider significance of those particular points, the reason why I suggest it's important that you should follow those 5 principles in making decisions is because creditors almost always would have a right to have your decision reviewed in court if it's a bad decision. Even if it's a good decision, if they think it's a bad decision, they will want to have it reviewed in court. And there's just one example. I mean, there's lots of statutory provisions across all the procedures that give creditors those rights. On the slide there, you'll see I refer to paragraph 74 of Schedule B1, which gives creditors the right to have your decision reviewed by the court if they think it is causing unfair harm. Now, generally speaking, the steer that we get from the courts is they don't like intervening. They would much rather that you made good, sensible decisions yourself, and it actually takes quite a lot for the court to step in and overrule a decision made by insolvency practitioners, because it's your job to make those decisions. You're there having to make the decision when it's important to make the decision, and they don't really want to be breathing down your neck about it all the time. So the circumstances in which the courts are likely to intervene is if they think the decision is perverse, or if they think it's a decision made in bad faith. And I'm now going to refer to another case that some of you may have heard of. It's the Wednesbury case. And this is an important case in the context of judicial review generally. I might even cover it on another coffee break briefing on another day, possibly. But essentially, the courts will say that they will not normally intervene in a decision which has been made by a public authority, not quite the same as an insolvency practitioner, but very similar. But they won't normally intervene unless the decision is so unreasonable that no reasonable insolvency practitioner could have made that particular decision. Or if you haven't followed the correct procedures in coming to the decision that you have, or if the decision that you have made is actually illegal. If it's one you just do not have the power to make. So that comes to the end of the basic points that I wanted to make today. Atlantic Computers, it's an old case, but I think it's a really, really important case in the context of insolvency generally. And in terms of looking at it beyond its implications for the administration ring fence, I think you should be using the guidelines from Atlantic Computers as a basis for making decisions generally, and particularly when other parties are trying to persuade you to make a decision in a particular way. In other words, when they're negotiating with you. And I think that impartiality and neutrality can get you a long way. Haven't seen any questions so far. If you'd like to ask any, by all means, please do so. I'll just go on to give you a few dates for your diary before I go. The next coffee break briefing is on the 9th of September. I think I may have said last month I was going to be talking about CVAs. I changed my mind about that, and I think probably I'm going to be talking about the new legislation dealing with tall blocks of flats. There was a Dear IP about that recently, and I think it's an interesting subject to look at in more detail. I've got a question, which is, why are insolvency practitioners not officers of the court in voluntary liquidations? It's a really good question, and really can't give a coherent answer to that, except to say that when I was looking at the various cases about where the courts have said that an insolvency practitioner is an officer of the court, there doesn't seem to be a clear and consistent approach to say that a voluntary liquidator is an officer of the court. I'm not sure that's right, and to me it would make more sense if a voluntary liquidator were to be treated as an officer of the court, but it's not something that the courts have necessarily been particularly consistent on. So I'm sorry, that's not a terribly helpful answer I can give to that, except just to say that the cases aren't really terribly helpful on that. Moving on to the other diary dates, 7th of October is the following coffee break briefing, and I'm thinking that I'll probably be covering third parties' rights against the insurers, the legislation there. Again, I saw a case relatively recently that I think provides an interesting context to that. We've got some conferences coming up in the autumn and next year. So we've got the CESCA conference at Reading University, where I understand bookings are going very well for that. I'm going to be speaking at that. I can't remember offhand what my topic is, but it'll be there on the flyer at CESCA. And similarly, I'll be speaking at the CESCA seminar at Denby's Wine Estate on the 10th of October. I'm hoping to attend as a delegate the R3 SPG Forum early in November. That's normally a good event. And then some dates for next year. The R3 Regional Forum for Southern and Thames Valley is likely to be in Bournemouth next year, likely to be on the 20th of March. And there will be the 4th Frettons Annual Insolvency Conference next year, probably in June. We haven't yet decided where, but if you keep coming to the coffee break briefings, you'll hear all about it. So with that, I think that probably brings this morning's session to a close. So thank you all very much, and see you again next month, if not before. Thank you and goodbye.